72 is notified, issued at a stage when presidential order under 356 is in operation. Number 2.
Yes.
That the President of India, under notification dated 19 December 2018, had assumed to himself the powers of the governor of the state of Jammu and Kashmir.
Yes.
Number 3, that 272 is issued with the concurrence of the government of Jammu and Kashmir, which meant a government where council of ministers is in place. Number 4, in terms of this CO 272, all the provisions of the Constitution of India are made applicable. Which could not be done as it had not earlier been done by Constituent Assembly. Or by the government of Jammu and Kashmir, or by the governor at any stage in 69 years. Number 5, when it says that all the provisions of the Constitution of India will apply, it would mean Article 368, which carried a proviso with it, would go, and 368 would also apply.
Can you please formulate that again?
Repeat that again.
So when it said all the provisions of the Constitution of India will apply,
Just 1 second. When CO 272 states,
yes, it says all the provisions of the Constitution as amended from time to time, Constitution means Constitution of India, shall apply in relation to the state of Jammu and Kashmir, except the following. That is 367 modified. Who says so?
sorry, I got this part. When CO 272 states that the provisions of the Constitution of India as amended will apply, except Article 367 as modified.
Yes.
What is the sequence?
It means that Article 368 would also apply, which provides for amendment of the Constitution.
According to you, then, as per 272, 370 was not no longer applicable.
Look, it is there.
That's the secret to your
But
argument.
it's a logical conclusion that can be drawn. We want to get drawn a logical conclusion.
No,
You want to get.
no, now you're stretching,
No, I'm just-
stretching it too much.
I am just reading English language. That's all. It is meaning.
You're stretching it.
I'm really trying to find out what is the purpose, what's it leading to.
Very.
I mean, how do we know?
No, it try to
If you
make.
don't find the text.
Reformulate the last point. I mean, just for doctrinal clarity, because this last point which you made is not really
Clause 2, sir, kindly say clause 2
of.
of this 272.
Just 1 second.
Please.
Clause 2, sir.
Small 2, right?
We'll understand it by the text of it.
Small 2.
All the provisions of the Constitution, that is Indian Constitution, as amended from time to time, which amendments have been carried out in the Constitution of India, shall apply in relation to the state of Jammu and Kashmir. Pause here. So entire Constitution, right from Article 1, right from Article 2 to Article 396, all would apply to us. That's all what I'm saying. And in that 368 would also apply.
Yeah.
Smiling at what was just this. It would also apply to us.
And,
Yes,
and what happens to 370 then?
So in any case, they have finished through 70. That was the intention.
No, that was the
What happened
second.
to
That's the second one. That's a two.
Yeah, I like
Not
it, sir.
272.
Yes.
Not 270.
They removed the form as well.
Anyway, we
They
were
removed the form. Now is the 367. Kindly see 367. What does it say in clause C? Reference to the government of the said state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. Just see this. So under 367, advice of the Council is also provided in this 272.
Yes.
Now when Council of Ministers is not there, yet the governor makes the recommendation. Now see the last part. In proviso to clause 3 of Article 370 of the expression Constitutional Assembly of the state referred to clause 2 shall read Legislative Assembly of the state. We pause here. This is one of the most important controversial part of 367. Now this is being done by the president, who himself was the governor, but mentions it that with the concurrence of the government of the state, he applies 367 in a modified form to us. Now, this is what the learned senior advocates have been arguing, that this 367, whether this can be invoked for purposes of changing the expression Constitutional Assembly into Legislative Assembly. That in turn will involve another question: what is this 367? Which is only one of the provisions of the Constitution related to interpretation. It says, unless the context otherwise provides. The provisions of the General Clause Act would apply for interpreting the Constitution. That's a simple language, the meaning of 367. Now, going to the main provision of 367, when it says that if the courts have difficulty in interpreting any provision of the Constitution or any word of the Constitution, then the court is entitled to seek aid of General Clause Act. This is
So really speaking, according to you, Article 367 is only an interpretative tool. And what you have essentially done is, by introducing a new principle of interpretation, you have amended the substantive part of 370.
Also, the first question would be jurisdiction, whether they could do so. This will come later, sir, what they have actually done. We are on the question of jurisdiction. Could the president, on the recommendation of the government of the state, where there was no Council of Ministers, could he make it? I am on the question of power. This is what I am saying all the time. Second, assuming he had the jurisdiction to do so, then while exercising that power, could he make an amendment in 370 subclause 3 with the aid of 367? Then the second question is, first is whether he had the power, he himself was the governor. Having delegated the power to the governor, but under his superintendent's control and directions. It's a very peculiar situation which is done, which is, no, we're not seeing such cases. That is why this case involves certain very issues of considerable importance, because you're also dealing with a federated state in a union. We're dealing with the rights of a state, not of a single individual whose fundamental rights are violated. The rights of a state are dealt with. It involves about more than 1 crore people. It involves more than 84,000 square miles of the territory. This case is extremely important, not only in this country, but everywhere. That's how this court will respond to what has happened on 4th and 5th of August 2019. This I would submit is not run-of-the-mill case, not an ordinary case. We are taking time. I am grateful to Lordship only for that. But then the cases of such nature, it involves so many considerations, the historical perspective. Without that, no person can understand 370. If he's not aware of the history of the whole matter. Then subsequently, what the governments have done, and ultimately what it did, just like the governments were allowing constitutional application orders, but somebody wanted to have all the golden eggs in one go. So they killed the hen on 4th. Governments were for last so many years giving concurrences, consenting to it. You apply this order, this order, this order, 54 in number. Somebody thought we got to kill the hen and get all the golden eggs.
All right, we've concluded this part now. Can we move on to the next part?
What I'm submitting is that this was patently without the jurisdiction of the president, and he is acting as the governor.
So you have challenged it on both counts, absence of power, and assuming the power did exist, the exercise of the power by seeking to amend Article 367.
Now, as a consequence of it, why I said this is the most important notification. As a consequence of it, when you change Constituent Assembly to Legislative Assembly, then things become, you have paved way for getting rid of it, because then now the Parliament becomes my Legislative Assembly in terms of Article 357. Because under the President's Order 356, now Parliament has the power to make laws for me. This is the whole constitutional manipulation. Not only that, they use 367 to get rid of 370, and then they kill 367 itself. Because in terms of the second notification, the whole of the constitution is applicable to me. Now, without any modification, without any exception. You use 367, you alter 370, you take it back, and then you kill 367 itself. This is the manipulation part of it. That's what we are agreeing with. It's not a bona fide action. It's not a legitimate action. That is not the way you deal with the states. Whatever may have been the situation in the state, whether it's national security, whether it's anything else, those are the matters of law and order. What is the 370 to do with what happens on the streets of Srinagar or in Kashmir? It has nothing to do with it. May I tell your lordships, all the laws which were applicable to us prior to 2019 continue to be applicable to us. Whether it's Unlawful Activities Act, Prevention and Detention Act, whether NIA Act, they continue to be. The difference is one. They say stone pelters have gone down, the militant activities have gone down. Those are the issues of law and order. I see no connection between that and 370. You got rid of 370 itself. It is not because of 370 those things were happening. There's no connection. Yes, you might have done development after that. That's a different issue altogether. Done or not done, I'm not here to comment on that. But 370, as a matter of fact, as a matter of law, that where a government wants to do something, but there is an obstacle, a constitutional obstacle. Therefore, the government wants to get rid of it. Just like in case of fundamental rights. Just in case of fundamental rights, if there's a fundamental right which doesn't allow the government to pursue a certain policy, then obviously the government has the power to amend that, saying that it cannot be done because we want to have a particular policy. 370 was altogether different. It gave us constitutional autonomy. But then the law and order situation is used as a matter of national security, and these two orders are passed.
Now, what next? Let's cross this bridge. Now we've got this point. The next point, what would that be?
Lordship wants me to conclude immediately, I will.
No, Mr. Shah, please don't harbor that in the least.
We've
So
heard
many
you.
years so many years in judging in a matter like this, I'll not do that unless you are satisfied that you are fully, not just that we should be satisfied that we have heard you, but you must also have that satisfaction.
I had so many things in this matter to say. Lordship must have noticed, I have not read even a single document.
That's because it's your mastery over the subject.
People asked me yesterday, what about instrument of accession? Of course, I could have read the document instrument of accession, but I told his Lordship, please see clause 8. If
I saw clause 7 also.
Read. I was reading the documents and then I would have taken 1 week. But since Lordship is not going into those
Actually,
documents.
that's why I told you to conceptualize the last point, because now it brings clarity and focus. Those 7 points which you made.
Just look at it, everything is covered, nothing is left.
Otherwise, what happens, Mr. Shah, is that typically we make notes based on the dialogue which is taking place. There's always a danger that you lose some point which was made, because the notes are made in the course of the dialogue. When you focus and formulate, then you're sure that you know.
I saw you also making the notes, but sometimes it is not like bullet points as they call it. This is without jurisdiction, because the job of an advocate here is, for example, there is no law on a point. I will have to persuade. Persuasion requires time by us. Persuasion can't be done, sir. President has no jurisdiction. Okay, sit down. That is the end of the matter. I can't do that. How can I do that? I can't explain who the president is.
After you have done the persuasion, you have to do the conceptualization.
Yes. That's why I did that. First exercise I have done as a counsel. I have in my own understanding that what could be the ultimate issue, what could be the result of this litigation, where such a serious issues are involved and relating to a state, a federating state, how should this court respond? And not only, there is one more important thing for us. This is the last forum available to the people of the state, that I would say, that your Lordship understands it. There is no one to take it back. As I see the political climate in the country, there's no one to take it back. It remains as it is. So therefore, all eyes are on this court, how this court will respond. And I, as a humble servant of this court, it's my duty to say what people think. The place from where I come, the people think about this 370, what has gone wrong, why are they hurt, why are they disappointed. Something will have to be said, because this is a last resort. If assuming, I don't know what your Lordship ultimately, when the Lordship will retire to the chambers and dictate the decision. But ultimately, what happens? Either it goes for all times to come, 370 as it is, or we get back what we lost on 4th.
Shah, we have to decide according to law or according to sentiments.
One more thing I wanted to say.
People are happy because of the development, because of the employment opportunities.
Nobody sells a country, sir. Whosoever may be in the government, this is our experience. Whosoever is the government, everybody tries to do his best. All government, nobody sells the country as such. Roads are made, maybe you make it a greater scale, somebody make it a smaller scale. Hospitals are built, education institutions, that all governments.
We need not go into all those, because.
No, sorry, Sir General said so. So therefore, I'm just saying that's all the governments do, of course. Good things always happen.
You're addressing a constitutional argument, and we have to deal with it.
Last one, which I would like to submit, because as I see, this is an important matter for us in that. I remember only one thing, few things I need your Lordship to know that. That is, sometime back, the great leader of this country, Mr. Atal Bihari Vajpayee, came to Srinagar and he delivered a speech. And he said that the issue of this Kashmir, I am going to solve within the purview of Jamhuriyat and Insaniyat. Unfortunately, the respondents killed both on 5th and 6th August. I would only pray when your Lordship retire to the chambers and dictate the judgment in this case. Let the words of truth and justice trickle from your Lordship's lips. That's what I would say. We are looking up to you. We have full confidence in this court, and we believe that the justice will be done to the people of the state of Jammu and Kashmir.
Thank you very much, Mr.
If anything is left, I would.
Thank you, Mr. Shah. Thank you very much. Who will be at
There
this?
were some judgments also which I wanted to cite for every submission which I made.
Can you, Mr. Shah, can you just do one thing? on the judgments, they will all be in the compilations which have been filed.
If anything is
You can
outside
maybe
that-
give us just 2 pages, a short,
Short.
just a sentence or two why you are relying on the judgment,
And-
just as Mr. Subramaniam did.
Now-
That will help us.
Now I understand. Sometimes it becomes too overwhelming for the judges also. You go on hearing a case all the time.
Not
same
really.
case.
I'll tell you what happens, Mr. Shah, is this, that at the end of it, when the dust and the din of the court has settled down and you are left with yourself in a small office to dictate a judgment, as all of us do, conceptualization always helps, because that's when you really have to sit back, close everything, shut yourself to everything else but the core of the case, and that's why it helps actually.
God bless you.
Thank you
for
very
giving
much. You've done it. You've
I've
done it
had these-
admirably. Thank you
I've
very
had
much.
these 2 things done. The constitutional autonomy is on 4th.
Yes, please give us that. Yes.
And number 2, also some few judgment, but I will indicate the paragraph only to support.
Absolutely.
What was the position earlier, what is the position now? I'm
Thank
grateful to you.
you, Mr. Shah.
Thank you.
We'll now have Dr. Dhawan.
Mr. Shah, I don't understand the electronics. Therefore, I'll have to rely on my friends. Call me a Luddite if you want, but that's the position as it stands.
But I noticed Mr. Shah was also on his iPad. He was pretty up on his iPad.
I can learn during this process or not is another matter.
Dhawan, the Chief Justice made me do it on the last Constitution bench. That was my first endeavor, I must confess.
The practice of each court differs. Some we go with all our files, some we come a lot with PDFs. Don't even.
We are evolving towards this, really.
No, this is a far better system, my lord. It's a question of getting used to it.
Absolutely. Mr. Dhawan, actually, it's the ease with which we have been flipping through documents, volumes, it's only because we are electronic. Otherwise, can you imagine, 5 court masters handing over
And
a
cases.
volume, then us giving that back to them?
Actually, if there's a brief, then there is no problem. When the brief is many briefs in large volumes, then the utility of this is, I think, much greater, where the records are very voluminous.
And the giving of books, my lord, handing over, flagging them for your lordships to look at. But I'm hoping I'll be assisted, my lord, by my brilliant assistants. My lord, I think when we start with the Constitution of India, we have to recognize that India is the most diverse country in the world. If you take the whole of Europe, the whole of Americas and part of sub-Saharan Africa, you have a diversity. And that diversity is totally and completely unparalleled. And that diversity is reflected in this Constitution. And it is not just Article 370 There are many other articles also, which I will show to your lordship presently, where the legislature of the state's consent is required, or concurrence is required, or it has a condition precedent to put in. And it is this factor your lordship will bear in mind, which will have an impact on other cases. Take, for example, the Podial case. The Podial case concerned whether there should be a reservation for bhutias and lectures. Now, this was obviously totally contrary to the Constitution, which says that you cannot discriminate on grounds of religion. We got a split decision, but bearing in mind the fact of the history of Sikkim and the fact that the Nepalese were considerably in power, your lordships then took a pragmatic decision as well as a principled decision, which I'll show to your lordship presently, to say, no, despite that particular provision, we have to honor the historical promises made to the people of Sikkim. And this is something your lordship will bear in mind, because our constitution is replete with promises to the people. I mean, take 3 and 4, my lord, to start with. This is the Achilles heel of the Constitution, that there is no territorial integrity. It is so peculiar to the Indian Constitution that we don't find a parallel as far as this is concerned in most of the constitutions of the world. Some joined the American Constitution with reservations, like Texas, most didn't. So you have to bear in mind that 3-4 is such an important provision, and it is central to the argument that I'm going to advance before your lordships. As Mr. Shah has pointed out, this had on the 4th of August a proviso. That is in CO 48. I can take your lordships through that because it's important to understand. This would be, my lord, in volume 3, PDF. PDF 13. I'm getting good at it, my lord.
You actually started using the language, you're saying PDF.
Right.
A PDF page?
No, it's much easier if one masters this. But I still believe in the quill pen, unfortunately, my lord. Because I find that whenever one has to write propositions, it is better to write them by hand rather than dictate them.
I would agree with you.
Much better.
Dr. Dhawan, there's one area where I still, despite my love for technology, I'm still conservative, which is when I read a book. When you actually read a book, you know, wrapping up at the end of the day, the joy of actually having paper in your hand is...
Well, that is going to finish, my lord. I have a huge library, very diverse, not just law. I wanted to give it to the Supreme Court, but there are no takers.
Who said that?
I said that to the Supreme Court Bar Association. This will have Marxism there, Eliot there, all kinds of novels there. If there are takers for it, the only takers at present offer I got was from Chanakya University in Bihar. Because that entire library is a collection of many things. Stuff on paintings, stuff on cinema. Now,
Dr. Dhawan, I mean, apart from this matter, please do walk across to the judge's library and have a word with our librarian, the registrar library, Ms. Uma Narayan. Please have a chat with her. I'll also speak to her.
I'll do that, Lord. Let them come and see the library, and whether the Supreme Court should have a purely legal library, Lord, or whether it should have a diverse library.
Oh, we have a diverse library. We pride ourselves on having books apart from law, actually.
That's right, and that's important, my lord. The question is always one of space, my lord. Nobody today has space. Most of my colleagues, my lord, Professor Galandra, Rick Abel, they all are sending messages, my lord, on Facebook. Does anybody want a library on law and society? It is available, please let us know. we will pay the expenses for transport. There is no space, my lord. That is the real difficulty that is faced.
I think there's something that in these
All the opinions and submissions are there, my lord. The unpublished papers are there. There are books that I never published, my lord. But who will want interested in that? Certainly not my children, my lord.
But actually, Dr. Dhawan, you may be, with respect, you might be wrong for this reason, that if you digitize this collection, today there are resources across the world where they are putting this out into the commons. And the idea is by putting it out into the commons to allow researchers globally to access this. So there's a great deal of interest actually.
My university came to me and said that we'll have to tear apart all these black volumes of yours. And I said, well, let's leave it for the moment.
I think Mr. Venugopal has, through Mr.
Venugopal, excellent.
digitized the entire library, which is now available for public access. Antiquarian books. He collects antique. That is digitized and anyone can access.
One of the finest libraries I have seen, of course, Mr. Ashok Sen had a brilliant library. Venu, of course, has a super library. There's a lawyer in Mumbai called Mr. Nadir Modi. I don't know if you ever have walked into his library. He has an amazing library in a place like Mumbai, in the heart of Fountain, where space is such a constraint. But he would never lend his books because he says, when lawyers take my books, they bend the book for photocopying it, and then the binding goes to seal.
We have this site now, beyond Court 5, going, that entire wing is totally vacant, 3 floor. Where during the COVID, the late Chief Justice Indra Malhotra wanted to donate her father's library. And at that time, we couldn't locate any place, so we went hunting. And that whole thing was vacant, but because of the COVID lockdown, that committee that I was part of couldn't get it, sort of access it. But if a new library could be made on this side, so if you also find out, the entire 3 floors are vacant because everything has moved across the road to the new administrative block.
As we know, we are now in the process of constructing a new building for the Supreme Court in this complex at the back.
They have all come as part of actually US's plan to have an additional building for the Supreme Court. So a lot of it will, is part of that planning will have to go. Maybe something more comes out of it. Space will be created. But you were mentioning with Dr. Dhawan, the Chanakya University. I had an opportunity to go to Patna and see almost a very large percentage of new judicial recruits in Patna, and very, very eminent people.
Mustafa has just taken over.
They came from this university, and I was interacting with them as to how many of them, and very large, I think almost 40% women, and they were a lot of them were products of this university who had got into the judicial service.
Because when I spoke to Faizan, he said, I spent 17 crores in building the library of Nalsa. And I have to do it all over again, so I'm happy with your books. I said, come and see the library first.
Incidentally, Mr. Singh, Mr. Sorabji's family gave us his personal collection, the Judge's Library. And in our Judge's Library, we have unveiled a new section called the Soli Sorabji Biblioteca. We have a very large oil canvas painting of Mr. Sorabji, and to commemorate him and his family when they were vacating the Niti Bagh house. Ms. Zina Sorabji called up and said, are there takers in the Supreme Court? So he said gladly. So our librarian went to his house. This was during the pandemic. She boxed all the books, brought them here, and then some Jindal Global Law School too.
What if I find any takers?
Good building here. We had a library in there, of course, most of it were reports. Now, my lord, the judges have, there is a proposal, my lord, to float a trust, and then my lord put up a new building or in this refurbish the same old building with, and therefore we are actually looking out for books. Therefore, if Dr. Dhawan's library is available, therefore, my lord, unless the Supreme Court librarian is quick on the day, we might actually tell him.
So many offers, Mr.
The
Dhawan,
offer I
short time.
made the CBA, my lord, a few years ago was, please take it. You don't need an oil painting of me, you don't need my name there, just take it and make sure that the diversity is maintained. If somebody wants to book on Renoir, he should be able to access it.
Probably do it at 4 p.m. today.
Mr. Dhawan, you have offers from north as well as south. Patna and Cochin.
Right.
Iowa City.
But this has happened. I know a university in Tamil Nadu. I think the former Attorney General gave his full library. A lot of these universities which have been strengthened with libraries donated by councils. GR donated his entire library there. So it's, right. It's certainly a place where lawyers can go and do some research. Should not become a samosa pakada place. As I said, short of that, yes. But true research, yes.
That's true, man. That's true.
That is a problem.
Now this is the problem.
This is the problem.
This is the problem which I have. Incidentally, 1 second. The new building which we are constructing of the Supreme Court, the entire ground floor is going to be used for the library for the SCBA, library for SCORA, for the Women's Bar Association. That's the whole. My learned brother, Justice Suryakant, Justice Sanjeev Khanna, Justice Gawai, and Justice Kaul and I were invitee members because we are not on the building committees of our 3 colleagues. Now just wait for the new building which we are constructing. We are showing it to the
As
SCBA.
technology is going, nobody will have to go to a library to read actually. That's what is going to happen. It's happening already. So that access to information will not be a problem.
So now that's why we have conceived of a new project, right? Our project is coming up now. Yes, Doctor.
Anyway, I was taking the first, my lord, article that I want to show to your lordships to demonstrate the diversity, because it's not just limited to those special provisions from 371A onwards. In fact, for Nagaland and for Mizoram, they say you'll need the legislature of the state to act. I'll show that to your lordships before you interfere with any customs. Now here is an impediment. It's very different. I'll show that to your lordships. Now, my lord, come to 3 and 4, my lord, to begin.
Article
I want to just show, my lord, volume 3, my lord, PDF 13. This was just I'm talking of the CO 48 that brings in the provision, my lord, into Article 3,
Or document 3.
document 3, I'm sorry.
What page? PDF? 1-3. Yes, we got it. 1954 CO.
Now, my lord, straight away at the bottom of that page, you'll see in Article 3 they shall be added the following further proviso, namely, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. $368 कहाँ है कौन से पेज पे Mr. Shah was referring to.
We read the proviso with Mr. Shah.
You read the proviso, my lord. I also wanted to read the proviso, my lord, to 368. And then I'll be done with CO 48. That's page 411 at the top, my lord.
PDF page number?
18.
18.
PDF 18.
In volume 3?
Yes, same volume.
You're reading the proviso, Mr. Dhawan?
I am going into the bottom of the page, my lord, on part 20, because these are relevant to us, my lord. If the only way out is an amendment, then these provisions are crucial both to Article 3 and 4, to 370, and a possible amendment, if any. I'll just read that, my lord, and I don't have to read the rest, because much of it has been read to your lordships. To Article 368, the following proviso shall be added, namely, provided further that no such amendment shall have effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under Clause 1 of Article 370.
So once there's an amendment to the Indian Constitution, that for the purpose of Article 370 is placed on the same footing as any other provision, so that you have to have a specific amendment.
That's right. Well,
by an order, presidential order under Article 371.
It's a two-stage process. The first is you must have an order of the President under Clause 1. Before that, you can't proceed with the amendment.
So Clause D of, subclause D of Clause 1 is then made operational. You have to have a presidential order under D.
That's right. That's right. But I'll come to those points a little later, because whether 370 could be amended at all or 3 and 4 could be invoked during President's rule is a major point that we wish to make at some point in time. Because all the provisions there relate to governments assisted by councils of ministers. As far as Article 3 and 4 is concerned, you have to circulate the bill to the legislature concerned. There is only one judgment of the Delhi High Court which goes the other way, but your lordships have insisted that this is a mandatory condition. This has not been done as far as the invocation of 3 and 4 is concerned. So let me take my lord to 3 and 4.
Here, page 367.
state by separating of territory.
Dr. Dhawan, which page are you on? I missed out.
I'm on the Constitution, my lord.
Article 3 and 4.
I'm sorry, my lord, that I should be more prepared in cross-referencing.
I was probably reading something with.
No. I'll come to my written submission in a moment, my lord. There is something elaborate on 3-4. Once again, I've quoted from the judgments rather than actually refer to them. I'll give your lordship the PDF numbers. Now, my lord, Parliament may by law form a new state by separation of a territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of the state. Increase the area of a state, diminish the area of a state, alter the boundaries of the state, alter the name of the state. Now, my lord, the proviso here, it was brought in, my lord, by the Fifth Amendment, as your lordship will see at the bottom of the page, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, unless where a proposal contained in the bill affects the areas, boundaries, or name of any state, the bill has been referred by the President to the legislature of the state, expressing its views thereon within such period as may be specified in the reference, within such further period as the President may allow. This, in my respectful submission, is a mandatory provision. The case law, my lord, suggests all you have to do is refer the bill. You don't have to refer future amendments to the bill. But this is a mandatory provision. And it will affect, my lord, the JK Reorganization Act of 2019. Because that is invoked, my lord, under Article 3 and 4. Territories are changed, names are changed, etc. The two explanations I'll omit for the moment, my lord, they were brought in after Berubari, my lord, because there was some concern as to whether you can take parts of territories and deal with them separately or not. And therefore, you have explanation 1. In this article, state includes the union territory, but the proviso state does not include a union territory. Now, Mr. Sibal was at pains to apply this particular explanation to the clause 1. He said there were many combinations. Actually, this did not, explanation 1 and 2 were not applicable to the state of Jammu and Kashmir. Then comes the consequential provision 4. Any law referred to in Article 2 or Article 3. Article 2 is relevant for Sikkim.
It contains such provisions.
Because it joins subject to some conditions which are there in Article 371, in the 371 series. Shall contain such provisions for the amendment of the first schedule and fourth schedule as may be necessary to give effect to the provision of the law, and may also, so first, my lord, is the amendment of the first and fourth schedule, and may also contain such supplemental, incidental, and consequential provisions, including provisions as to the representation in Parliament and in the legislature or legislatures of the state or states affected by such laws the Lord Parliament may deem necessary. Now, these supplementary provisions are what is contained in the JK Reorganization Act. The argument made is you have representative democracy in the Union Territory, you may not have it in Ladakh. But nevertheless, the entire statute is really made under Article 4. Now, my lords, if I may show some other provisions to your lordships on diversity, my lord. This I will explore later when I show your lordships the decisions on Article 3 and 4. Very strange provision, my lord, in Article 164. For the special provisions, my lord, on SC/ST, your lordships will see there is an entire separate chapter on it. And our affirmative action is very different from that of any affirmative action in the world. So 164, my lord. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition, be in charge of the welfare of scheduled castes and backward classes. Now, this came in, my lord, by way of a small alteration for Odisha. The name was changed. But this is an important provision which once again shows the diversity, my lord, that exists. Then, my lord, your lordships will come to Article 244, my lord. Sorry, my lord, before that, my lord, the Union Territories, if I may just indicate that to your lordships, that's part 7.
239, right? 239.
Now, my lord, all the amendments by and large to creating Union Territories, except for Chandigarh, my lord, have been made by constitutional amendments. Here we see the creation of a territory, my lord, under Article 3 and 4. So let us have a look, not save as otherwise administration of Union Territories. This was put in by the 7th Amendment. On Article 3 and 4, Mr. Chandra Singh, my lord, will take your lordships to the State Reorganization Committee report. I didn't go into that, my lord, because he is going to develop that argument. Every Union Territory shall be administered by the President, acting to such extent as he thinks through an administrator to be appointed by him when with such designation as he may specify. Notwithstanding anything contained in Part 6, the President may appoint the governor of a state as the administrator of an adjoining territory, or where the governor is so appointed, he shall exercise his functions as such administrator independently of the Council of Ministers. So, my lord, as soon as you become a Union Territory, and subclause 2 applies, the President may appoint a governor of a state, he may appoint somebody else, but at the end of it, it says he shall exercise his functions independent of the Council of Ministers. Now, this, of course, has changed, my lord, in the context of Delhi, etc., but I'll come to that in a little. Then, my lord, your lordships will see 239A. Parliament may by law create for the Union Territory of Puducherry a body which is whether elected or partly nominated or partly elected to function as a legislature for the Union Territory or a council of ministers, or both with such constitutions, powers and functions in each case as may be specified. Puducherry, my lord, came from a constitutional amendment. Parliament was authorized, my lord, to make a statute, and it did so. The next, my lord, is a provision your lordship is very familiar with, 239AA. That is Delhi, and it contains, my lord, in the amendment itself, not through a circuitous route, my lord, of 3 and 4, but in the amendment itself, it contains the provisions for a legislative assembly, division of powers, my lord, then, my lord, failure of constitutional machinery, and then finally 240, my lord. The President may make regulations for the peace, progress, and good government of the Union Territory of Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. To this we can now add, my lord, Ladakh, as a consequence, my lord, of the changes that have been made. But of course, it's not amended, my lord. It's done as a consequence of Article 3 and 4. And therefore, the President completely takes over. There is no parliamentary government at all, no reference to the people, and there is a lieutenant governor or a governor in charge. And that is the fate of many union territories, my lord, unless provisions are made. When you convert a state into a union territory, and there is some doubt as to whether you can, because without explanation one, it is clear we are talking about states. And this would be the only occasion in the history of India where a state has been reduced to a union territory. It is, and now when we talk of transformative constitutionalism, it is important to bear in mind what this really means. As far as Ladakh is concerned, a provision similar to 240 will apply, which is there, of course, in the Reorganization Act. And as far as Jammu and Kashmir is concerned, it becomes a union territory with the limitations that are there in the JK Reorganization Act. This is unprecedented, Malad. If, for example, you wanted to make a union territory of Delhi, there was special reason, you passed an amendment to the Constitution. But here, by a circuitous procedure, you have converted through Article 3 and 4 two union territories from a state, one with some representative government, one with none. Then, my lord, if I may take your lordships to 244. I'm just, my lord, on the question of diversity of our constitution, which makes it very different from others and more exciting than others.
We'll continue on Wednesday.
Your Lordship,
the 16th, right?
Wednesday.
Wednesday.
There's a small housekeeping matter. There are additional volumes of case law and documents Mr. Dushyant Dave's team have given. In fact, it appears that they had given, because there was a Google form, it might have been missed out by them. So request that also be taken on record. There are about 3 cases.
But were they given in advance with the other volumes?
Yes. We had
the Noti Council.
We don't seem to have the record, but it appears that they had given of the other volumes. Case law. It was case law and documents. One.
Is there any overlap with the case law and documents already on the record?
Done the deduplication. There is no overlap.
There is no duplication. All right. Okay.
And there is also a chart of intervention application, the essence of intervention.
All right. That we'd like to have, so that we'll have.
Also, I'm obliged.